Welcome to Frank Bruno Law. I am Frank Bruno. Welcome back. Welcome for the first time. Today's topic. Well, I'm going to tell you about a conversation I had with a client today. This person is doing an administration on behalf of a relative of his. Right? So I don't give too much information. Be secretly cryptic. But the sum and substance of this is that the person that's my client has a safe deposit box, and he and the person that he's administering the estate of, not a wife, not a spouse, had some belongings in his safe deposit box. It was actually a joint box. So upon the death of the individual, my client still has a key. Can you go into that box and take the belongings out? Well, I've had situations where, upon disclosing to the bank that one joint holder of the safe deposit box had passed away, the bank froze the account, froze the box, and didn't let them open up the box without permission of the court. So, what should you do? Should you go to your box and open it up because it's yours? Well, the idea, the inclination would be to go into the box and take out what's yours and leave what belongs to the other person in the box. So in the event that you need permission and authority of the court to open up the box, the only things that would be inside of the box would be the items of personality, right? Jewelry, or sometimes money, sometimes important legal documents. Those items that remain in the box would be the ones that belong to the deceased person. Because it doesn't really make sense to have your belongings in there should you need to open up the safe deposit box in front of a bank representative, because they take an inventory. So if you had a piece of jewelry, they would take an inventory of it, and the court might want to have an assessed value of that jewelry. So to speak to me about all issues safe deposit box, I get thrown off, right? You want to call it a safety deposit box. I think it's a safe deposit box, just like a safe. FrankBrunoLaw.com